Good afternoon, this is Dimitri Lascaris coming to you from Kalamata, Greece on June 9, 2024 with my latest rant of the week. The subject of my rant this week will be lawyers. Now, I have to say at the outset that this rant is many years in the making because although over the course of my decades of legal practice, I have been privileged to work with and continue to work with many fine, honorable, decent human beings in the legal profession, I have witnessed all too often during the course of my decades-long career that the people at the very top of the legal profession, those who exercise the most power, privilege, and influence and have the greatest wealth, time and time again, fail to show even a minimum of human decency. The immediate trigger for this rant is a series of events that has taken place at the Toronto Metropolitan University's Lincoln Alexander School of Law since October of last year. The story begins, of course, on October 7th when Palestinian militants launched devastating attacks on military bases and settlements ringing the Gaza concentration camp. According to Israel, in those attacks on October 7th, Palestinian militants killed 1,139 persons in Israel, of whom approximately 1/3 were military and security personnel, and according to Israel, 36 of whom were children. 2 days later, on October 9th, 2023, Israel's Defense Minister Yoav Gallant, who is now the subject of an application for an arrest warrant at the International Criminal Court, declared openly that Israel would deprive the Palestinian population of Gaza, whom he described as human animals, of all food, fuel, and water, effectively starving them to death, that he would also lift all restrictions on Israeli military, and that no one in the Israeli military would be held accountable for their actions in Gaza by any military tribunal anywhere. It's important to note that in January of this year, the International Court of Justice, by a margin of 15-2, ruled that this very language was evidence of genocidal intent when it came to the conclusion that it was plausible that Israel was committing genocide. Now, the administration of the Lincoln Alexander Law School, the deans, decided in these circumstances to issue a statement to the student body on October 11th. In their statement, they implored the students to have deep empathy for the desire of both Palestinians and Israelis for statehood, and at the same time to condemn the atrocious attacks on civilians. This statement did not acknowledge in any way, shape, or form, explicitly or implicitly, that years earlier, multiple mainstream respected human rights organizations in Israel and in the West had declared Israel to be an apartheid state. The statement of the deans didn't acknowledge that for decades, year after year, Palestinians had incurred far more civilian casualties than Israelis. It didn't acknowledge that for over 50 years, Israel had brutally occupied Palestinian territory and had been building settlements in the West Bank, occupied Palestinian territory, in flagrant violation of international law. It acknowledged none of these things, and it effectively amounted to a both-sidist, wishy-washy utterance of nonsense. Now, by October 20th of last year, Israel had massacred over 1,400 Palestinian children in Gaza. This constituted nearly 40 times the number of children that Palestinian militants were alleged by Israel to have killed in Israel on October 7th. In these circumstances, dozens of law students at the Lincoln Alexander School of Law signed on to a letter that was addressed to the deans of the faculty. And in their letter, they expressed their unequivocal solidarity with the Palestinian people. And they went on to say that Israel is a settler colony, which is true, that it is not a real country, which is certainly arguable, and that Palestinians have the right to all forms of resistance, which as a matter of international law is absolutely correct. They not only have the right to peacefully resist their brutal oppression, their servitude, their humiliation, they also have the right to employ armed resistance, albeit within the bounds of the laws of war. And in their letter, they said that they condemned those who only condemned the war crimes of Hamas, referring to Hamas's acts on October 7th as war crimes, but who didn't also condemn the war crimes of Israel. So within their letter, there was an unambiguous acknowledgement that some Palestinian militants on October 7th had committed war crimes and that they agreed with the condemnation of those crimes. What they took objection to was the failure of many within Canadian society to also condemn the crimes of Israel, which happened to be far worse than any Palestinian faction has ever committed. Now, this letter, as I indicated, was intended only for the consumption of the deans, but somebody decided to leak it to the public. And within a matter of hours of it becoming known to the public, all hell broke loose. As you can imagine, one Zionist lobby group after another demanded the heads of these students on a platter. And the people who were perhaps most notable in insisting that there be severe punishment inflicted upon these students were members of the legal profession. I'll come back to that in a moment. Under intense pressure, on October 23rd, 3 days after their receipt of this letter, the administration of the law school and the university put out a statement in which they distanced themselves from the letter and openly accused the letter of having anti-Semitic content. So in other words, they were effectively accusing these dozens of conscientious law students of having engaged in blatant acts of anti-Semitism. They made this accusation without consulting with the students, without seeking to understand why they had said what they had said, without any kind of an investigative process. They effectively engaged in outright reputational destruction with no due process whatsoever. Of course, this wasn't adequate for Zionist members of the legal profession. The fact that the reputations of these students had just been dragged through the mud and effectively destroyed with no due process whatsoever. So 23 esteemed, privileged, influential members of the bar in late October of last year issued an open letter. And in their letter, they accused these students, dozens of whom are women, of having endorsed rape. Not only rape, but of also having endorsed torture and kidnapping, including of the elderly and the civilian population of Israel. They also said that these students had engaged in flagrantly anti-Semitic behavior, and they demanded that there be some form of real accountability for these students and that the mere destruction of their reputations was not adequate. And they also included in their letter a thinly veiled threat. The threat was that the legal profession, the law firms upon which students rely for articling jobs so that they can gain admission to the legal profession after they finish their legal studies, that they would boycott the entire student body. Not just those who had signed on to this letter of solidarity for the Palestinian people, but all the students, even those potentially who had no role whatsoever in the making of this letter. In other words, they threatened to engage in an act of collective punishment against the student body of Lincoln Alexander School of Law. Now, collective punishment, where have I heard about that practice before? Oh yes, it's exactly what Israel has been doing to the Palestinian people for over 50 years. Now, under intense pressure, including from these august, eminent, influential, and privileged members of the legal profession, the administration of Toronto Metropolitan University decided to set up an external review. And for that purpose, it hired a former Chief Justice of Nova Scotia, J. Michael MacDonald, to assume the role of a decision maker in what was, in effect, a complaint lodged against these students by the administration of the university. The complaint being, of course, that they had engaged in anti-Semitic behavior and had thereby violated the university code of conduct. And under his mandate, if Justice MacDonald determined that they had in fact violated the university's code of conduct, he was to recommend sanctions, including potentially their expulsion from law school. At that point, Justice MacDonald invited all of the students who had signed this letter to meet with him. He also invited, if they were represented, to have their legal counsel attend the meetings with them. But he didn't confine himself to those interactions with the signatories of the letter. He also consulted a number of external stakeholders, including pro-Israel groups, including a couple of signatories of this notorious lawyer's letter calling for the heads on a platter of the students who had signed this letter. And he also met with experts in anti-Semitism. Now, at the outset of this process, I was approached by a student by the name of Alina Lee, who had signed this letter, and she asked me to represent her, and I did that on a pro bono basis because this was ultimately a matter of conscience. We met with Justice MacDonald. He engaged in months of investigation, and about 10 days ago, he issued his report. And although he found that the letter was imperfectly expressed, that the intentions of these students had not been articulated in a manner that was best designed to minimize offense or hurt to people who disagreed with them, He also found that this was a perfectly valid exercise of free expression, that the students had not engaged in anti-Semitic behavior, and that they did not violate the university's code of conduct. And for that reason, he did not recommend any sanctions, of course. He also was quite pointed in chastising the administration of the law school for falsely accusing the students of anti-Semitism, and he took a run at 2 places in his 169-page report at these 23 members of the legal profession, essentially accusing them of having engaged in the very type of behavior which they accused the law students of having engaged in, those who had signed this letter. Namely, he accused them with complete justification of having been insensitive, of having rushed to judgment, and of having used offensive language. Now, one would think that having been chastised by a former Chief Justice of the Nova Scotia courts, and one would think that after the International Court of Justice had ruled that it was plausible that Israel was committing genocide, one would think that after Israel had massacred over 16,000 Palestinian children, and that even the pro-Western prosecutor of the International Criminal Court had announced that he was going to seek indictments for war crimes and crimes against humanity against the Prime Minister of Israel and the Defense Minister of Israel, one would think that after all of that, these 23 lawyers would show a modicum of contrition, that perhaps they would apologize, retract their letter, or at a bare minimum, express some reservations over what they had done. But no, you'd be wrong about that, folks. In fact, some of these lawyers have decided to double down. One of them, Jonathan Rosenthal, came out and said that he was shocked, disturbed, and aghast at the conclusions of Justice MacDonald, that the only reasonable interpretation of this letter was that it was anti-Semitic. And he even said in an exchange with me over LinkedIn that he thought that law firms were going to effectively ignore the decision of Justice MacDonald, Chief Justice MacDonald, and would effectively boycott the law school anyways. Jonathan Rosenthal is not only a bencher of the Law Society, he is also a white-collar criminal defense attorney. In other words, he represents rich fraudsters. Now, Mr. Rosenthal, as a bencher, is charged with the responsibility to ensure good governance at the Law Society and set policy for the regulation of the legal profession. You see, the legal profession in Ontario and other Canadian provinces operates under a model of self-regulation. I'm going to come back to that in a moment. The benchers of the Law Society are effectively the board of directors of the legal profession in Ontario. There were 3 other benchers besides Mr. Rosenthal who signed this notorious letter in late October of last year. The first of those was Howard Levitt. Now, Howard Levitt first came to my attention in January of this year when I was invited to debate him by 640 AM radio in Toronto. Mr. Levitt, you see, is reputed to be one of the finest employment law lawyers in the country, and as far as I can tell, he represents large corporations and employers rather than the workers whom they systematically exploit in this country. At the time of the invitation, I did a little research into 640 AM Radio Toronto, and I quickly determined that it was owned by the Global News Network. The Global News Network has an unambiguously pro-Israel and Zionist editorial posture. I know this from painful personal experience because when I was running to be the leader of the Green Party of Canada in 2020, during the week where the party's members were actually casting their votes, the Global News Network published a hit piece on me in which it accused me of various and sundry forms of impropriety because I had the audacity to defend the Palestinian cause. Nonetheless, I decided to accept this invitation because the 640 AM radio station in Toronto happens to have a quite significant audience, and I thought that this would be an opportunity to impress upon them the gravity of what Israel was perpetrating upon the Palestinian people in Gaza. So I debated Mr. Levitt in early January of this year, and during our debate, in an unhinged rant, Mr. Levitt actually had the audacity to say that what Israel was doing to Gaza was the most moral war in human history. Not only that it was a moral war, but that it was the most moral war in human history. Now, you can listen to the debate between Mr. Levitt and me because I posted a recording of it on my website, and I'm going to paste a link to that article where you can find the recording of the debate in the description to this video on YouTube, and I'll also post other links which are pertinent to my rant today. And you can decide for yourself who won that debate. I happen to think that Mr. Levitt didn't fare particularly well. And in fact, I learned from a well-placed source that the Zionist community in Toronto wasn't particularly happy with Mr. Levitt's performance. And so they found somebody else to debate me. That somebody else was a person by the name of Larissa Waller. Larissa Waller was supposed to be a communications expert. She had served as the director of communications for the right-wing, fanatically pro-Israel government of Ontario, run by Doug Ford. Now, when I showed up at the studios of 640 AM radio to debate Miss Waller, she was standing in the lobby with a well-known, influential figure from the Zionist community in Toronto. And she was holding in her hand a notepad. And when we walked into the studio, just before we began our debate, I noticed that there were a number of talking points on the notepad. And she proceeded to read from them without having the slightest clue what the hell she was talking about. The other two benchers, by the way, who signed the notorious lawyer's letter in late October of last year were Sidney Troyster, who is a commercial real estate expert, and Will McDowell, who earns the big bucks by representing Canada's depraved corporate community. It's also notable that one of the signatories to this lawyer's letter was Brian Greenspan, who's widely considered to be one of the finest, if not the finest, criminal defense lawyers in Canada. Interestingly, Mr. Greenspan, who falsely accused dozens of female law students of endorsing rape, recently accepted a retainer from Frank Stronach, a 91-year-old billionaire who is accused by the police of having committed sexual assaults over a period of some 30 years. Personally, I think the most perverse aspect of this whole sordid affair is that whereas the students who took the side of the victims of genocide and apartheid were subjected to a McCarthyite witch hunt, people in the legal profession, including people at Lincoln Alexander School of Law, who openly support the genocidal regime and whitewash its heinous crimes, haven't been subjected to any kind of meaningful scrutiny whatsoever. One such person, by the way, is Associate Dean Sari Graben, who repeatedly in the month of October of last year tweeted and retweeted posts that were unabashedly pro-Israel, including commentary from the Israeli military. Now, as I've indicated, the model of governance in Ontario's legal profession and throughout the provinces in Canada is so-called self-regulation. Well, I'm here to tell you, my friends, that self-regulation is an oxymoron. Self-regulation effectively means no meaningful regulation. And one obvious indicator of this is the fact that lawyers are so damn expensive that most members of our society can't afford to retain them. We have, in fact, a crisis of access to justice in Canada, not only in Ontario, throughout the country. Why do I know this? Because many members of the bar, including many judges and appellate judges, have recognized that to an increasing extent, people are coming into the court system in Canada without legal representation. A recent study found that even people who make as much as $100,000 a year or more cannot afford to hire a lawyer, precisely because lawyers are so damn expensive. If you had meaningful regulation of lawyers in this country, there would be some kind of constraint on their income. Now, one way you could at least modestly constrain the excessive compensation of many of these lawyers is to have a requirement that all lawyers devote a significant amount of their time to doing pro bono work for people who cannot afford a lawyer, and particularly those who are marginalized and oppressed. How would that limit their income? Because the more time they have to devote to doing legal work for free, the less time they will have to do legal work for the big bucks. However, there is no such requirement in Ontario. It's entirely possible for a lawyer to make gobs of money without ever doing any significant amount of pro bono legal work for an entire damn career. And here's a humble suggestion for those who are charged with regulation of the legal profession in Ontario. Maybe if you required lawyers to do pro bono legal work to a significant degree, and maybe if you imposed the greatest burden for pro bono legal work on those lawyers who make the most money, maybe if those lawyers were required to actually interact with and represent the marginalized and oppressed, they would finally, ultimately show a real sense of compassion for those people. And that's my rant of the week from Kalamata, Greece on June 9th, 2024.